Hello, everyone, and welcome to another episode of Sterling Live. My name is Caitlin Brower, and I am Sterling's social media manager. And I have the pleasure of going live every single Tuesday across Facebook, LinkedIn, and YouTube at 1 p.m. Eastern. And I sit down with some of Sterling's finest, some of the best people we have working with us. So, some of the best colleagues I have. So I am super excited today because I am joined by Mark Sward. He is our Vice President and Global Head of Privacy. And today we are talking about privacy laws in Canada, PIPEDA, and the new Consumer Privacy Protection Act. So Mark, thank you so much for joining us today. Can you go ahead and introduce yourself to our audience?
Absolutely. Thank you so much, Caitlin. So happy to be here. As you said, I'm the Vice President and Global Head of Privacy for Sterling. So really my job is to oversee Sterling's global privacy program, how we comply throughout our worldwide footprint with privacy laws, of course, PIPEDA in Canada, but also the GDPR in Europe, the CCPA in California, and many others around the world. And that's, part of my role is managing our internal compliance with these laws, but also I play a role because of the type of business that we run, supporting our clients when they need to comply and they're trying to use our services in a way that complies with privacy laws, and to provide some thought leadership and guidance around that. And I've been with Sterling since 2010, so I just celebrated 11 years. And I've been.
Congratulations on the.
Thank you. Yeah, it's very exciting. Clearly, something's working. But I've worked in different roles around the company. I've been in operations, actually fulfilling background checks. I've been in client success roles and in privacy for about the last 7 or 8 years. So I have a pretty good global insight into the things we do.
No, that's great. And obviously your role seems pretty important, obviously. So you're doing a lot of good things for Sterling. So thank you for that. And again, congratulations on the anniversary. That is truly impressive. And again, we are doing some things right. So thank you again for joining us today. So for everyone who is viewing live right now across Facebook, LinkedIn, and YouTube, if you do have questions for Mark throughout the show, feel free to send them in and I'll field them to him as I see fit. You can ask questions by going to the comment section on this post, and you can submit your questions that way. And again, we'll review them and we'll have Mark answer some of your questions. So please send them in throughout the show. So let's go ahead and get into our topic today. So we are covering a lot. I'm very excited to dive deeper into a lot of the details here. So I do want to start with a PIPEDA overview. And I kind of laugh when I say that a little bit because I did have to have you tell me how to pronounce this. So I'll give you your opportunity to give our audience a little bit of intel of how you do pronounce it correctly. But can you provide our audience with the definition of PIPEDA? And how to pronounce it and kind of the trick of how to pronounce it.
Well, it's funny that you raised that actually, because so just to set the stage, PIPEDA is how I like to say it, is the Personal Information Protection and Electronic Documents Act, which is a federal law in Canada that's been around since 2000. So anyone in the privacy world is going to probably be pretty well aware of PIPEDA because it's one of the older comprehensive national privacy laws. That said, there is no universal agreement on how to say it. There are people who say PIPEDA and PIPEDA and various other alternatives. Even within the Office of the Privacy Commissioner that enforces the law, I think we hear more than one pronunciation. So I've settled on PIPEDA, but I don't need to see any flame wars in the comments. If anyone disagrees,
they might be.
I respect your any other pronunciation. But yeah, as I said, PIPEDA it was kind of ahead of its time. There weren't a lot of comprehensive national privacy laws when it came around. There are a lot more today. And a lot has changed in the world of privacy in the last 21 years. But we'll get to that. We'll get to what's changing. First of all, what is PIPEDA? It's kind of an unusual law in the way it's structured. It doesn't set out a bunch of specific things that you must do or must not do. Instead, it's designed around 10 principles that are the pretty commonly globally accepted fair information privacy principles.
Right.
And they are focused around a few core privacy concepts. The organizational concepts of accountability. Organizations are accountable for how they use data, and openness, the requirement of organizations to be transparent about what they do with information and how they protect it. It creates a bunch of individual rights, which are, of course, really key to privacy: the right to know what your data is being used for, how it's being collected, the requirement that organizations get consent if they're going to use personal information, except in certain exceptional circumstances, the right to access your data if a company has it, and the right to challenge compliance. If a company's not following the rules, people have the right to call them out for that. And there's also principles around proportionality, making sure that you're only collecting what you need, only using it as much as you need to, retaining it only as long as you need to, sort of data minimization. And then, of course, the sort of basic requirements that if a company is going to have personal information, it's got to be accurate, and if they're going to have it, they have to keep it secure. So that's sort of PIPEDA in a nutshell.
Yeah, no, so great nutshell. So thank you for doing that overview there. So you did touch on areas of, when you're pointing at, specific companies and, how it relates to them and what they do. So for PIPEDA, who and what does it apply to? So getting into the details around that.
And that's also a very good question, because it's not as simple as it just applies to everyone.
Yes.
Generally speaking, PIPEDA applies to the handling of personal information in commercial transactions in Canada, as well as handling of personal information in employment in the federally regulated sector in Canada, which, because Canada has a two-tier system of federal and provincial government, there are some sectors of the economy that are regulated at the federal level, and all the rest are regulated at the provincial level. So really, it's when it comes to commercial activities, PIPEDA covers pretty much everybody. When it comes to employment, it mostly doesn't. So there are some provincial laws that actually cover employment in those other sectors. And also, I think it's important to point out that PIPEDA allows any province in Canada to come up with its own privacy law that basically supersedes PIPEDA. So there's 3 provinces that have laws that supersede PIPEDA right now. That's British Columbia, Alberta, and Quebec. So in those provinces, PIPEDA doesn't really apply very much. I mean, there are certain situations where it does, but for the most part, it's the provincial law that applies. But at the end of the day, they're all based on the same principles.
Understood. Yeah, no, and that's definitely interesting for sure to kind of look at it holistically and understanding, who exactly it does apply to. And again, it's not as easy of saying, well, it applies to everyone, because like you had just said, it doesn't. So great overview of PIPEDA there. So we're also talking about today, though, the Consumer Privacy Protection Act. So I do want to go into detail on that. So again, a quick overview for our audience. Can you give us an overview of what CPPA is? Another acronym for you, but I did say it, the Consumer Privacy Protection Act, but CPPA, an overview for our audience.
Yes, absolutely. So that's, I think, the more exciting thing. PIPEDA has been around for a long time, hasn't changed a lot. Everybody, everyone certainly in the Canadian privacy world has a pretty good idea of what it's all about. But there's currently a bill before the Canadian Parliament. It's referred to as Bill C-11 because it enacts a couple of different laws. But this would repeal most of PIPEDA. It would repeal the privacy parts of PIPEDA and basically put in place a brand new privacy law for Canada, which will be called the CPPA, the Consumer Privacy Protection Act. So, if it is adopted, which presumably it will be, because I think it has sufficient support in Parliament, it will significantly modernize the Canadian privacy regime. And this is driven both by a demand from the public and from privacy regulators to have a more modern law that reflects the realities of technology today, as well, and also a law that has some teeth, because PIPEDA really doesn't have a lot of enforcement power, and the CPPA will. And another really key piece that I think is important to call out is that in the last 21 years, European data protection laws have evolved a great deal. Right. And the Europeans, when they're looking to allow data to leave Europe and go to other jurisdictions, they're going to look at the local laws to see whether they're adequate. And they have deemed Canada to be adequate, but that decision is very old. And with changes in European law and the introduction of the GDPR, that decision may not stand if Canada doesn't get its act together and put in place a more modern law. So that's really, there's a number of things driving this forward. But that's what the CPPA is intended to accomplish.
So you did just touch on that with the Consumer Privacy Protection Act, there will be more of, enforcement or like room for enforcement. Can you explain what that exactly means and why, for example, something like PIPEDA doesn't have that room for enforcement?
Yeah, and I think that's why companies are both in Canada and elsewhere are going to be paying attention to the CPPA once it's enacted, because PIPEDA really, so it's enforced by the Office of the Privacy Commissioner of Canada, and they have the right to investigate. They have the ability to go in and receive complaints, look into what companies are doing, look at their practices, make recommendations for changes. They can make public statements about where they see things going wrong, so naming and shaming, but they can't really force anyone to do anything, and they can't impose any fines. So while it's nice to have a law, if a company says, well, I can comply with the law or not comply with it, and really there's not going to be a penalty, well, it makes it hard to invest money in compliance. And CPPA has fines going up to $25 million or 5% of global corporate revenue. So very, very serious compliance efforts there.
Okay, yeah, and definitely good for our audience to know that. So hopefully everyone has their pen and paper out and took notes of those monetary fines right there. Definitely a lot. So can you explain some of the key changes Canadian businesses will have to adapt to under the CPPA?
Yeah, for sure. So there's a lot of things that are really kind of housekeeping in terms of clarifying the definitions around what exactly is personal information and what's the distinction between the company that makes decisions about how data is used, what Europeans might call a controller, versus the service party that they engage, who doesn't really make decisions but still handles data, which in European terms would be a processor. So making those kinds of distinctions, which will be really helpful for companies to manage their programs. But it also makes some more groundbreaking changes. It goes into the concept of de-identified data and data where personal characteristics or personal identifiers have been removed, and what organizations can do with that data. It gives new rights to individuals that companies in Canada have never had to contend with, like the right to ask for data to be deleted or moved to another organization in some cases. There are some new concepts it introduces around data sharing within industries and codes of practice for industries and how they handle data, which it can lead to some really interesting innovation. We've seen the same principles come up in Australia and in Europe, and it's led to some interesting new concepts around the way people can control their data. So there's some good technological innovation stuff there. And there's also more detail about transfers of data outside of the country. Right now, there's nothing really in PIPEDA that says you can't or what you can do when you're transferring data outside of Canada. All there is some guidance, and the regulator doesn't even seem to be 100% sure that they agree with the guidance. But there's a bit more detail in the CPPA, which is not onerous. It's not too difficult, I don't think, to comply with. But it does give a little bit more guidance. But I think the biggest thing is just the fact that this law will put in place some requirements to have a good, solid privacy program and privacy practices, and the teeth to back it up. So those who don't follow will there's definitely a good reason to invest in that.
Yeah, definitely, and I think that is great. And there is a decent amount of things that these businesses do need to adapt and kind of understand, as we shift to, this newer, area of privacy. So you yourself, being a privacy expert professional, as these businesses adapt, what would be your best piece of recommendation for them, like as they're looking to, resources or just, any piece of advice you have to these businesses that are going to have to start adapting in multiple ways, like you just outlined for us?
I think the big thing is for organizations that are selling services or interacting with consumers in Canada, whether you're in Canada or not, now is the time to start paying attention. I think, because compliance is going to become a more necessary and more expensive function, as soon as this law is passed, as soon as this bill is passed, and as soon as we know the date on which it's going to take effect, I think we're going to see the market rates shoot up for privacy professionals. Now, I'm not saying that you should come knock on my door and offer a big salary, but there's going to be a big demand for privacy expertise and for building a privacy program, and you cannot start soon enough because the tools are all there. So that's really the key, to get those tools in place so your company's ready to comply on day one.
Yeah, that's a great piece of advice there for our audience. So I want to touch upon any other legislative changes that we can discuss today. So are there any other legislative changes in Canada that we should be aware of right now?
Well, it's funny you mentioned that.
Is it a surprise on the show? We're announcing something?
As I mentioned, PIPEDA does allow for provinces to have their own laws. And the oldest one, in fact, is Quebec, which predates PIPEDA. Quebec has had its a really pretty good comprehensive privacy law since the mid-1990s. And Quebec is also in the midst of a major reform. Quebec is the second largest province by population, and so it's definitely an important economic force in Canada. It's the center of French-speaking Canada, and therefore any company that wants, any organization that wants a national footprint is going to have a French language footprint, and that's going to really be directly, touching Quebec. And Quebec's privacy bill, which is currently, as we speak, being studied before a parliamentary commission, let's say it's elicited a little bit of controversy. It brings in a lot of new concepts. It goes much further than the federal bill, and it puts in place a lot of really confusing requirements on organizations. And the privacy community in Canada is a bit up in arms about this Quebec bill because it does things like requiring organizations to post every detail of their privacy and security policies on their websites, which I assume is not actually what the government wants, but it does seem to say that you have to have all these policies and you have to make them all public, which is really hard for a business to do. But even more so, even more difficult to grasp is it puts really onerous restrictions on data leaving the province of Quebec, even to Ontario or somewhere else in Canada. And it's really hard to see how anyone's going to be able to comply because it would require case assessments, contracts, etc., even for just a one-time transfer of data. So it's a little scary. We'll see what comes of it. There's the commission may amend it. We'll see. But there's definitely some nerve-wracking things coming out of Quebec, and so we're keeping a very close eye on that to see where it goes.
Keeping a close eye on it for sure. But yeah, so we did cover off on a lot of interesting things today. And I do want to let our audience know, if you do actually go to our Canadian website, so it's sterlingbackcheck.ca, Mark recently authored a blog up there, so where he does cover off on a lot of things we discussed today and more. So I do want to let you guys know that you can go over to sterlingbackcheck.ca and check out this latest blog. It is called Background Screening Compliance in Canada, How Sterling Backcheck Supports Your Organization. So I would definitely go check out that article because, again, there is a lot in there that we did discuss today, but more. I will go ahead too, once we are done with this live show, I will go in on Facebook, LinkedIn, and YouTube and get that URL in there. So it's just an easy one click away for all of our audience members right now. So I do want to remind everyone across Facebook, LinkedIn, and YouTube, you can ask questions in the comment section. So go ahead and submit your questions if you do have them as we wrap up the show today. But in the meantime, while we are waiting for any potential questions to come in, Mark, I do want to get some final thoughts from you on our discussion today. And you already gave out so much useful pieces of information. So I'm excited to see what your final thoughts are.
I'm mostly just looking forward to seeing where things go. I think this is a really interesting year in privacy for Canada. As a Canadian, but also as a global privacy practitioner, I've it's sort of been disappointing over the last number of years that we never see anything new out of Canada. All the excitement comes from Europe and the U.S. So I'm excited to see some movement in Canada and some really tough thinking and some tough conversations about how to comply and how privacy regulation should work in the future. And I'm excited to see more companies really paying attention to privacy, because it's important. It matters to Canadians. It matters to people worldwide. And this is something that's going to require some work. So I'm excited to see where it goes. I'm excited to watch these bills develop and to work with Sterling's clients on how we adapt, screening programs and the services and products we offer to these new realities.
Well, I am thrilled that you were able to share this excitement coming out of Canada with me today and with our audience. I feel beyond honored that, we're getting some excitement out of Canada and you were able to sit down and share it with me. So Mark, thank you so much for joining us today on Sterling Live. It was absolutely an incredible episode, very informative. We'll make sure that our audience continues to be updated on everything that is, coming out of Canada. But thank you so much. And thank you to our audience as well. Again, this was a tremendous episode.
Thank you so much. It's been a pleasure.
Of course. And again, we will see you every Tuesday at 1 p.m. Eastern. So we will catch you next time. Again, Mark and our audience, thank you guys so much. And we'll see you next time.